with you 10 of my favorite lessons from this timeless classic, How to Win Friends and Influence People. Number 1 favorite timeless lesson from How to Win Friends and Influence People. Become genuinely interested in other people. You can make more friends in 2 months by being interested in them than in 2 years by making them interested in you.
I show you how deep the rabbit hole goes.
Like you, be strong to hold the powers of the sun.
Listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I'm your host, Pavarotti, and I'm here to discuss the Idaho 4 case. And, you know, I was going to do the really powerful video on Murphy and all the aspects around Murphy this morning. But as I started putting it together, I realized really quick that is an impactful video with some really impactful information. And to gather all of it around that subject is going to take me some time. I'm not going to just be able to put it together quickly. So I wanted to reach out and give you a case update because I noticed in my comments yesterday that a couple of things. Number one, people do have questions about this secret hearing that's coming up. So I'm going to go into some detail about what that is and what it's about. But I also, this is why I always try to bring receipts. I thought I'd shown the receipt on the fact that they didn't process the mattresses for forensics. And when I mentioned that in one of the videos yesterday, I noticed a chain because somebody was saying, goodness, I can't believe that. I'd have to see a receipt for that or else, you know, I can't wrap my mind around it. Well, and that's why I always try to bring receipts. I thought I'd mentioned it, but I hadn't. So I'm going to show the receipt for that one because that is a fact. It's in the court docs. So I will provide that receipt so everybody's on the same page. And then I also want to get into that secret hearing that's coming up and tell you exactly what it's about. But also, as I look deep into it, there's always something just a little bit interesting about everything that we look into. There is a strange thing when I look at the Idaho Code as it relates to what the prosecution is wanting to do with that secret hearing and what the prosecution is trying to accomplish with it. But the code that they cite in their motion for it, when you look into the details on it, it's kind of interesting. So I'll share that with you in this video. And it's not going to be a long one. I'm not going to get into too much. I just wanted to make sure everybody's up on the latest information. And then I hope to have you the Murphy video tomorrow night as a Sunday night special. So without me continuing to talk, let's just get right into it. Okay, so this is the judge's order on defendant's motion in limine regarding vague and undisclosed expert testimony. And then when we come down here to Jenny Ayers, and you notice it's got the little 2 besides Jenny Ayers. Jenny Ayers is a forensic scientist with the Idaho State Police. And basically what she's disclosed is, her role including collecting DNA, blood stains, latent fingerprints, hair and fibers, and shoe impressions. She'll explain what DNA is and why it may be present and all that good stuff. But then in her rebuttal testimony, says her rebuttal testimony concerns Idaho State Police's crime scene investigation procedures generally and the team's processing of the crime scene at 1122 King Road. And that's including identifying areas that contain probative evidence. In addition, the lab report number 11, and field notes for the team's work are referenced by the Bates within the disclosure. Now, defendant argues Miss Ayers' case-in-chief disclosures do not provide any opinions about the crime scene processing or about the DNA at issue at this case. Thus, he asked the court to limit her testimony, qualifying her background, and her work in Lab Report 25. As to her rebuttal disclosure, Defendant argues again that it fails to provide any opinion about the crime scene investigation procedures, and it does not clearly state what she did in processing 1122 King Road and what her opinion regarding that work. Defendant challenges misapprehend the type of expert Ayers is. Much like law enforcement, Miss Ayers is a hybrid fact expert. Now, I know I went over that with you, but in addition, Miss Ayers' rebuttal disclosure is replete with explanations about why and how the crime scene investigation was carried out at 1122 King Road, and her testimony will be allowed as disclosed. But look right here at this little number 3. So this statement right here has more to it. In addition, Miss Ayers' rebuttal disclosure is replete with explanations about why and how the crime scene investigation was carried out at 1122 King Road, number 3. So when we go down here to number 3 and we extend what the judge was saying in that sentence, for example, the disclosure discusses why the team focused on certain areas of the home as opposed to others, why they decided not to collect mattresses and bed frames, and why they swabbed and or applied a Medo Black where they did. So why they decided not to collect mattresses and bed frames, y'all. There's your receipt. Now, I can't wait personally till trial to hear testimony from people like Miss Ayers and hear their explanation of why they wouldn't process the mattresses of unaliving victims that I watched 2 different mainstream morons last night suggest that the crime was some type of pseudo-sexual fantasy type thing, yet no processing of the mattresses. Yeah, can't wait for those reasons that are given with that one. But now let's move on to what this secret hearing that is going to happen it's going to be a remote hearing. They're not going to come into court. It's going to happen on May 5th. And it was initiated by Josh Hurwitz, former U.S. attorney known for prosecuting Aryan Nights. And it has to do with the autism spectrum disorder diagnosis by the defense's experts and the state wanting to do their own diagnosis. And the defense did object to it. So that's why there's going to be a hearing on the matter. But let's go through the docs and I'll show you the progression. So we don't get to see the actual motion that was filed because it was filed under seal and the judge agreed to seal it. But here is the motion to seal the state's motion for examination of defendant pursuant to Idaho Code 18207, which we're going to look at in a second because that is interesting. And for an extension of time to complete rebuttal penalty phase expert disclosures and declarations and exhibits in support. So this is not going to be relating to the guilt phase of the case. This is preemptive examinations done by the state, or the state wants to do, so that if it does get to the penalty phase, if Kohberger's found guilty, when they're discussing sentencing, the state really wants this in place for some reason because they probably think it's going to help them in sentencing, or maybe they have other things in mind. I don't know. We'll look at 18207 and let you decide. But again, this is all just for the penalty phase if Kohberger was found guilty. And you can see the Lake Tahoe County prosecuting attorney hereby moves the court pursuant to Criminal Rule 32G1 and Idaho Code 74124. But again, this is pursuant to 18207. For an order sealing the state's motion of examination of defendant pursuant to 18207, and for an extension of time to complete the rebuttal penalty phase expert disclosures, as well as the declarations provided in support filed herein for the following reasons. The motions, declarations, accompanying exhibits reveal personal, private information of defendant and affects his privacy interests. Specifically, the filing reveals mental health information about the defendant, including psychological, psychiatric, neurological information, and diagnosis of defendant. The filing also reveals the nature of mental condition examinations already conducted, the type of examinations and testing the state seeks to perform, some of which is personality testing to which defendant objects. Some of which is personality testing to which the defendant objects. In addition, the state has redacted the name of a psychology expert who is no longer working on the case. Should be no longer. But everybody talks about the expert that, is it Cy Ray? Look, it says right here clearly. In addition, the state has redacted the name of a psychology expert who is no longer working on the case, of a psychology expert. They've redacted the name. We already knew that one of the defense's experts in the penalty phase had passed away. So you can bet that was one of the psychology experts in the case. So that's the expert that's no longer going to be on the case. There's nothing to do with the guilt phase experts. This is a penalty phase motion. But you can bet that what the defendant objects to, some of which is personality testing to which the defendant objects, you can bet that the state is trying to do some backdoor stuff right here to include in the psychiatric and neurological testing. Well, if they're wanting to perform personality tests, personality test would determine if, they could use the word sociopath or psychopath in trial, and they're trying to backdoor it through this, and that's why the defendant's objecting to it. That can be easily ascertained. And this is a slick move by Josh Hurwitz. But one thing I did want to point out, and I haven't mentioned this to you. Oh, dang it, it don't have it on this one. It'll have it on another one. Let's see. Okay, so here is the notice for the hearing on May 5th to discuss these matters. And I wanted to point this out, right? Because you've got the defense team, which is Ann Taylor right here, Alyssa Massoff, Jay Logsden, who's kind of a sidebar attorney because he can't show up to trial, and Bicka Barlow. But over here in the prosecution side, one thing I don't think we've mentioned yet is when you look at the prosecuting attorneys in this case, you got William Wofford Thompson Jr., Ashley Jennings, Joshua Hurwitz, Jeff Nye, Special Assistant Attorneys General, and Madison Allen, Special Assistant Attorneys General. So I don't know that anybody has talked about Madison Allen as of yet, but this is yet another Special Assistant Attorney General that was assigned to this case. So that is, in effect, 5 prosecutors working now to prosecute Bryan Kohberger. Specifically, what they've added Madison Allen for is for jury selection. Apparently, she has a specialty in selecting juries, so they have brought her on to do just that when jury selection time comes around. And jury selection is a very, very key aspect of a criminal case. Seating the right jury can make or break the case. So they brought in their specialist for that just to show you this is such a cut and dry, overwhelming evidence case against Bryan Kohberger that they need to bring in a specialist just to pick the proper jury. Give me a break. See these little scales of justice right here? They mean nothing in Idaho. All right, so when we go to the case summary on this case now, you'll see that on April 29th, we have an objection, and it's a sealed defendant's objection to state's motion for examination of defendant pursuant to Idaho Code 18207 and for an extension of time for the rebuttal penalty phase experts. And then after the defendant, they filed that motion, Kohberger's team objected to it. So once they objected, then the judge set a notice of a hearing the very next day, and that hearing is scheduled for May 5th right here. And you can see that they filed the motion to redact or seal the reply. Then they motion to redact or seal filed records, motion to seal the reply in support of state's motion. So they've sealed everything, and there's a remote hearing because it's medical information and it's part of the penalty phase. But here's what's interesting, because again, they're citing Idaho Code 18207 for this examination. Let's read 18207, and I think that's where things kind of get a little bit interesting. And I know they always put these codes in small letters here, but this is Title 18, Crime and Punishments, Personal Liable, Principles, and Accessories, 18207. And that is mental condition, not a defense. Provision for treatment during incarceration. So mental condition is not a defense in Idaho. All right, so you can't plead not guilty by reason of insanity. But according to 18207, it's not a defense, but it does include a provision for treatment during incarceration, reception of evidence, notice and appointment of expert examiners. Mental condition shall not be a defense to any charge of criminal conduct. If by the provisions of Section 192523 Idaho Code, the court finds that one convicted of crime suffers from any mental conditions requiring treatment, such person shall be committed to the Board of Correction or such city or county official as provided by law for placement in appropriate facility for treatment, having regard for such conditions of security as the case may require. In the event a sentence of incarceration has been imposed, the defendant shall receive treatment in a facility which provides for incarceration or less restrictive confinement. In the event that a course of treatment thus commenced shall be concluded prior to the expiration of the sentence imposed, the offender shall remain liable for the remainder of such sentence, but shall have credit for the time incarcerated for treatment. So apparently, if Kohberger was found guilty because of this section of the Idaho Code, he would not go to the wherever they house the death penalty inmates on death row. He would actually go to a treatment facility. And I guess that means he would go there until he was deemed not to suffer from whatever he was suffering from and face the death penalty. So according to this, I'm going to read here a little bit further, but according to this, if Kohberger was found guilty and sentenced to death, then he would spend all of his time in a treatment facility before the execution, if it ever occurred. And then it's nothing herein is intended to prevent the admission of expert evidence on the issue of any state of mind, which is an element of the offense, subject to the rules of evidence. So yeah, it's not a defense, but it is a stipulation to incarceration. Nothing herein is intended to prevent the admission of expert. I just read that. No court shall, over the objection of any party, receive the evidence of any expert witness on any issue of mental condition or permit such evidence to be placed before a jury, unless such evidence is fully subject to the adversarial process and at least following particulars. Well, the jury is not going to come into play because the judge excluded it from the trial. So, raising an issue in the middle of mental condition in a criminal proceeding shall constitute a waiver of any privilege that might otherwise be interpreted to bar the production of evidence on the subject. Upon request, the court shall order that the state's expert shall have access to the defendant in such cases for the purpose of having its own experts conduct an examination in preparation for any legal proceeding in which the defendant's mental condition may be an issue. So that's clear as day. So that means they are going to have access to Kohberger to do their own testing. And I see what the defense is doing. They're just objecting to the personality testing portion, not the mental testing. The court is authorized to appoint at least one expert at public expense upon showing an indigent defendant that there is a need to inquire into the question of the defendant's mental condition. If the examination cannot be conducted by reason of the unwillingness of the defendant to cooperate, the examiner shall so advise the court in writing. In such cases, the court may deny the party refusing to cooperate the right to present evidence in support of a mental status claim unless the interest of justice requires otherwise. All right, so Kohberger couldn't go in there to take those tests and then just sit there silent and not participate, because then the defense would not be able to bring up their records of the tests that were done by their experts in the penalty phase if Kohberger didn't cooperate with the state's experts on their side. So very interesting, but I thought the most interesting part to that is that first section where if he was convicted, he would never even go to prison. He would spend his time in a mental health facility. That sounds really, really, really similar to another case that started up there in Idaho and ended up in Oklahoma. Anyway, I wanted to give everybody an update on those things. And also at the beginning of my video, you've seen one of my favorite books, and that's How to Win Friends and Influence People. And the main principle in that entire book is the very first principle, and that is if you want to influence people, then the number one way to do that is become genuinely interested in people. And that's what I try to do. And I'm doing my best to try to not, start fights with anybody out there now. And I'm trying to respect everybody's opinion and listen. So I'm generally interested in listening to their opinions. However, last night I was listening to somebody, and it's amazing to me if they truly believe Kohberger's guilty, whether they say they do or not. You can always hear how their arguments are just a little bit skewed. I mean, I heard this person talking about how if Bryan Kohberger had GPS data proving that he was somewhere else, such as a photograph of the night sky with EXIF data logged into the photograph, that the only way that that could be true is if Ann Taylor had already gone to the Supreme Court, showed him that evidence, and this case would be over. And I mean, I don't know if it's just their mind trying to prove to themselves that Kohberger's guilty or what, but I mean, they just don't logically think through stuff. When you actually dive in and look at the court docs and you really see what's going on, and you see that the prosecution has an expert witness that is an expert in Celebrite, and they're also an expert, according to them, in deep fakes, well, you can clearly see that regardless if Kohberger has that evidence or not, the prosecution is going to try to refute it. So until trial, when it's presented, if it's not refuted by the prosecution, there's no taking it to the Supreme Court and saying, look, I've got a picture with a photograph that proves I wasn't there. If the state says we don't believe it and we'll produce an expert that says otherwise about that evidence, well, then you got to go before the jury and let them be the trier of fact. You cannot just up and jump to the Supreme Court and have the thing thrown out. Sometimes these people, I don't know if they believe what they're saying. And then the other thing they said was absolutely blew my mind. They said that for the defense to bring forth an alternative perpetrator defense, that they would have to go through the process just like law enforcement would, produce probable cause to the judge, and the judge would have to issue an arrest warrant for those alternative perpetrators before they could present it at trial. And when I heard that, my head almost exploded. And that is a fallacy. And if you just read the documentation there, person, and it says in Idaho Rules of Evidence that you can bring forth an alternate perpetrator but you must see State versus Meister to understand what rules you need to follow for that alternate perpetrator defense to apply. And Meister makes it clear that you have to tie the perpetrator to the crime somehow. Not just somebody else could have done it, but actually tie them in some way to the crime. By no way does it say you have to have strong probable cause evidence enough to get an affidavit from the judge for an arrest warrant. Some of these folks out there, I mean, they have delusions of grandeur as it relates to some things in this case. But just in case anybody heard those statements from that person, no. No. But anyway, I try to give everybody the benefit of the doubt as much as I can. Please like and subscribe to the channel. Post your comments, thoughts, criticisms. And until next time, Pavarotti is out.